the Companies Act provisions with respect to name of companies. Section 15, Prohibition of registration of companies by undesirable names. Subsection 1, no company shall be registered by a name in which, in the opinion of the registrar, is undesirable, having regard to such provisions as may be prescribed. Alright, so the name of the company must conform to morality and decency and not give certain bad impressions. Alright? So the person at the registrar who you suggest the name of the company to, they will decide whether or not it's an appropriate name. Alright, subsection 2. If through inadvertence or otherwise a company on its first registration or on the registration by a new name is registered by a name which, in the opinion of the registrar, too closely resembles the name by which a company in existence is previously registered, the first mentioned company may, with the sanction of the registrar, change its name. That means if you go and register a company, and after that, after the registration, they realize it's too close to resemble another company name, then you know, as the director of that company, may change the name and shall, if the register so directs, within 6 months of being registered by that name, change its name within 6 weeks. So they give you a notice for change the name within 6 weeks of the date of such direction, or within such longer period as the register may think fit to allow. So basically, they don't allow two companies to have the same name, or the name must not resemble too closely. Right? You have various reasons, but for example, suppose you register a company and say is XYZ electrical installation. Then you have another company in existence for a long time, years, named XYZ electrical installation or XYZ electrical or so. Then you know, you careless. Or let me change this scenario. You have a company named XYZ electrical, and then somebody careless now, and they register XYZ electrical installation or so, and they go burn down the people in house or building, and the company news say, oh, XYZ electrical go burn down, and the people in house and them no have no, them careless and them no have proper qualifications, them not competent. No, you well established, well, you have good reputation, long time in the business, and that kind of press come out. New customers, when looking online and see all sort of bad news about XYZ electrical, they don't know that it's not you, it's not your company. But they don't care. They say, why? I don't want to associate with this name at all. Because somebody else do all sort of careless work and spoil the name and reputation of XYZ. So you suffer as a consequence. So they won't allow that kind of thing to happen. No two companies must have the same name or too closely fitting the same name. Alright? Subsection 3. If at any time after a company has been registered, it appears to the registrar that the name under which it is registered is undesirable, the registrar may notify the company accordingly and may, in such notification, direct the company to change its name, and the company shall change its name within 6 weeks of such direction, unless within that time it has lodged an appeal to the court against such direction. You know that this is the Supreme Court. The Supreme Court deal with companies. Section 4. The court shall thereupon either cancel or confirm such direction, and its decision shall be final and conclusive. So the court, the Supreme Court, might say keep the name as it is, or it might say do as the registrar of company says. After that, no argument. You just have to, or you or the registrar of companies just have to do what the court says. Section 5. If the direction is confirmed, that means the court says you must do as the registrar of companies says. If the direction is confirmed, the company shall change its name within 6 weeks of such confirmation. Subsection 6. If a company makes default in complying with a direction under subsection 2, or except where an appeal has not been disposed of under subsection 3, so they tell you to change the name and you don't do that within 6 weeks, it shall be liable to a fine not exceeding $1,000 for every day during which the default continues. $1,000 per day until you change the name. Subsection 7. Subsection 3, 4, and 5 of section 17, that yet to come, shall apply to a change of name under this section as they apply to a change of name under that section. Right. Section 16. Power to dispense with limited in the name of charitable and other companies. Subsection 1. Where it is proved to the satisfaction of the minister that an association about to be formed as a limited company is to be formed for the promoting commerce, art, religion, science, religion, charity, or other useful object, and intends to apply its profits, if any, or other income in promoting its objects, and to prohibit the payment of any dividends to its members, the minister may, by license, direct that the association may be registered as a company with limited liability without the addition of the word limited to its name, and the association may be registered accordingly. So basically, this is really a non-profit, and shall on registration enjoy all the privileges and, subject to the provisions of this section, be subject to all the obligations of limited companies. So if you register a non-profit organization, even though it's a limited liability company, you won't be obligated to add the word limited at the end. Subsection 2. Where it is proved to the satisfaction of the minister, A, that the objects of a company registered under this act as a limited company or of an existing company, being a limited company, is registered to the matters specified in subsection 1. So is registered as a non-profit, and to objects incidental or conclusive thereto, and B, that its constitution, that by its constitution, the company is required to apply its profits, if any, or other income in promoting its objects, and is prohibited from paying any dividends to its members. The minister may by license authorize the company to make by special resolution a change in its name, including or consisting of the omission of the word limited, and subsection 4, 5, and 6 of section 17 shall apply to a change of name under this subsection as they apply to a change of name under that section. So here now, as we see, it says to apply its profit, if any, or other income in promoting its objects. That means if it make any profit, since it's a non-profit organization, it would be illegal for you or anybody else to try to get rich by being paid its profits, right? You're supposed to have a fixed amount of money that you compensate those who work for the non-profit. But even if the company, the non-profit, make a whole heap of money, you're supposed to use that money for the purposes of promoting, as it says, its objects. It is prohibited from paying any dividend to its members. Alright? Now, the word dividend. I look for it online. I see this in Investopedia. A dividend is the distribution of a company's earnings to its shareholders and is determined by the company's board of directors. Dividends are often distributed quarterly, that means every 3 months, and may be paid out as cash or in the form of reinvestment in additional stock. The dividend yield is the dividend per share and is expressed as a dividend divided by price as a percentage of the company's share, such as 2.5%. Common shareholders of dividend-paying companies are eligible to receive a distribution as long as they own the stock before the ex-dividend date. Alright, so that is dividend. So it's money that the company pay out to its shareholders. If it's a non-profit, you're not allowed to go and pay out dividend to those members of the company, to the members of the company. Alright? Now, subsection 3. A license by the minister under this section may be granted on such condition and subject to such regulation as the minister thinks fit, and these conditions and regulations shall be binding on the body to which the license is granted, and where the grant is under subsection 1 shall, if the minister so directs, be inserted in the articles. A body to subsection 4. A body to which a license is granted under this section shall be exempted from the provisions of this Act relating to the use of the word limited, as any part of its name, the publishing of its name, and the sending of list of members to the registrar. Subsection 5. A license under this section may at any time be revoked by the minister, and upon revocation, the registrar shall enter upon the register the name limited at the end of the name of the body to which it was granted, and the body shall cease to enjoy the exemptions and privileges, or, as the case may be, the exemptions granted by this section, provided that before a license is so revoked, the minister shall give to the body notice in writing of his intention, and shall afford the body an opportunity of being heard in opposition to the revocation. Subsection 6. Where a body, in respect of which a license under this section is in force, alters the provisions of its articles with respect to its business, the minister may, unless he sees fit to revoke the license, vary the license by making it subject to such conditions and regulations as the minister thinks fit, in lieu of or in addition to the conditions and regulations, if any, to which the license was formerly subject. Subsection 7. Where a license granted under this section to a body, the name of which contains the word Chamber of Commerce, is revoked, the notice to be given under the provision to subsection, the proviso, I guess N should be on the end of this, to subsection 5, shall include a statement of the effects of the provisions of subsection 2 of section 17. Alright, let's look back at this proviso. I looked up that word online. There is such a word. It's a new word to me. It says, is an article or clause, as in a contract, that introduces a condition. Is a conditional stipulation. Okay. So, read that part again. Where a license granted under this section to a body, the name of which contains the word Chamber of Commerce, is revoked, the notice to be given under the proviso to subsection 5 shall include a statement of the effect of the provisions of subsection 2 of section 17. Provision of subsection 5. Let's look back at subsection 5. A license under this section may at any time be revoked by the minister, and upon revocation, the registrar shall enter upon register the name limited. So you'd have to use the word limited at the end of the company name. Alright. So, section 8, or subsection 8, the procedure in cases of application for licenses under this section shall be in accordance with that set out in the 10th schedule. We will look at section 17, change of name, in a different video. What we covered here so far were section 15, prohibition of registration of companies by undesirable name, which includes names that are too closely resembling other company name, as well as power to dispense with limited in the name of charitable and other organizations. So we'll look at section 17, change of name, in our next video.